Good morning to everyone. My name is Kay Williams. I am the president of the Barbados Bar Association. Joining me here today, we have the distinct pleasure, Ms. Lynn Marie Simmons, who is the convener of our Law Reform and Legislation Committee.
Good morning.
Okay. Yes, good morning. So before we actually proceed with our presentation, there was one point that we wanted to raise in limine. And the reason why we are raising this is that we want to be absolutely sure that the version of the bill on which we are commenting is the same as that which is before the members of this honorable committee. It's come to our attention that there's a version of the citizenship bill in circulation. It has a significant difference. It refers to a point system, and it is different from the version which is on the Parliament website and the one which our team reviewed. So in these circumstances, we just wanted to make sure that the section 4, is it section 4 of the...
There was a section 4 that was contained in another version. So we are wondering if there was a redrafting of the bill and that the one that we have is the most recent and current version. Because it may be that that other version was an earlier version, but that was circulated amongst stakeholders.
Sorry, the reason you see me looking away is that I was waiting for the clerk to rejoin us because there's a question before the committee of different versions of a bill. Now, I'm hoping that what the clerk will say is that the version of a bill that is before Parliament is the version of a bill. But I will let him respond.
Yes, Madam Chair, that is exactly correct. I'm not sure which version of the bill the bar has and where they got that version from.
We have the version that was published on Parliament's website as well as gazetted. That's the one that we've been critiquing. But we were made aware by a stakeholder that there is another version that contained provisions which expand the grounds for applying for citizenship. That may have been an earlier version. So we just wanted to clarify that we are working from the most recent version. That's the only reason why we've interjected at this point.
But the version that you were told by the stakeholder, I mean, unless that stakeholder is the office of the Chief Parliamentary Counsel or Parliament, that stakeholder really can't speak for what is the version of the bill.
We are quite pleased to hear that because the version of the bill, that particular section expanded the categories and also spoke to a point system that we would be we would not wish to have to comment on.
I think though that, with all due respect, we can't be asked to make any commentary on something that may be circulating. Parliament has done its work to have made available the version of the bill that is under consideration by the Parliament, and that is what we are considering today.
Certainly. Thank you so much. And we will note that accordingly. Thank you so much. So we are here today, but really, Ms. Simmons and I represent a team of attorneys at law that looked at the bill. Among that team included attorneys at law in various aspects of their practice, a number of them in corporate and commercial, and that is where, their practice, it would intersect with the citizenship and immigration bills. We have those as well for whom immigration matters and appeals have formed a large part of their practice. Overall, the comments come from practitioners who have upwards of 30-plus years of experience dealing with or interfacing with citizenship and immigration matters. So the concerns or the comments stem from the work of the committee and the review by that team. Now, in respect of the comments of the committee to which we indicated, the bar, and we are quite willing to have the committee examine and ask us further about the comments which we have before you. But we would urge this honorable committee to examine a number of things. First of all, I believe the first concern we have is whether there is a guiding policy document, which has been updated. We are aware of the 2009 Green Paper on immigration reform. We are also aware of the 2019 white paper, which was a cabinet paper, which was the amended version of the 2009 paper. The issue with the 2019 and the 2009 policy papers is that, of course, they were prior to, number one, Barbados transitioning to becoming a republic, and the consideration of what a Republic Barbados looks like and the Republican Constitution may look like, from which citizenship rights flow. Number two, the two policy papers also predate the enhanced protocol, the CARICOM enhanced protocol for freedom of movement. So one of the things when we look at immigration and citizenship reform, normally you need that policy paper to really give, to be that guiding force to show what informs the provisions of the bill. And so the first question we ask is whether there is a revised policy paper. And the reason we've asked that is because what's in the two policy papers, the Green Paper and the White Paper, do not accord with the provisions or are reflected in the provisions of the citizenship and immigration bills. So be grateful for a bit of guidance on that. Thank you.
Just because you've kind of set a framing question, and
Yes.
My response is a general response because I am not the proposing minister.
Understood.
But what I would seek to clarify is that it is not in every case that legislation is brought on the heels of a specific policy document. Legislation often flows from overall development policies, in this case, population policies. The population policy is really the overall policy framework from which this legislation flows. So while the committee will certainly pass on the specific question, I do not think that legislation must flow from a specific policy document that bears the same name as the legislation. Governments across the world often use development frameworks development strategies, and broader policy documents to guide legislation. As a matter of fact, the population policy has an implementation plan that, that lists enhanced immigration policy and citizenship legislation as one of the things that is flowing from that piece of work. So without prejudice to what the minister may respond, I just wanted to kind of give that context.
Thank you so much. And if that were so, then we would have turned to the policy on population to provide that context, but we were not aware. So therefore, again, one of the first things that the practitioners were asking for was what really is that guiding policy, because the bills before this honorable committee are at variance with the previous two policy papers. And on the question of population as well, our team sounded a note of caution. And again, those who practice in the area of citizenship and immigration, both reform as well as the practice of it in general as intersects and interfaces with their legal practice, they indicated that primarily those jurisdictions with a low population and those who, for whatever reason, have to be guided by population to either contribute to their social security or contribute to the economy, those jurisdictions focus on residency. And they have a firm residency policy as opposed to a citizenship policy. Why is that so? Because the research, and we have all of the, we can provide the further details, links, and so on. The research shows that residency as opposed to citizenship is a greater contributor to the economy. Why? A citizen does not necessarily have to contribute to the economy. If someone acquires citizenship without more, that is the highest standard of their status. It is not linked and ought not be linked to other forms of their status, which includes whether they work, whether they contribute. If we have jurisdictions such as New Zealand, which is a gold standard, New Zealand focuses, it's an island nation, it's a Commonwealth nation, it's a common law nation, and has a low population, but has to look for a viable workforce to contribute to its economy. As a result, New Zealand has a very clear policy where they emphasize residency, work residency, where the immigration policy is to have persons who enter the country and contribute to the economy. And they tie the residency to the contributions to the economy, whether it be by establishing businesses, and that's something you have to be very careful navigating that, whether establishing businesses, whether they come to work, however, and they even go so far as to say they look favorably on those who contribute to charities and so on. So they actually indicate, we want you to migrate, to contribute, and it's by way of residency and not citizenship. In addition, we have practitioners 30 plus years, and they said typically one practitioner who has 30 plus years said that I keep in contact with my clients. And those clients who have successfully obtained citizenship, 80% of them actually do not reside in Barbados for whatever reason. In other words, they might be from the diaspora, it is important to them, it's sentimental reasons, or they obtain citizenship and then they further migrated. So from that particular practice, and they have a large practice in immigration and in citizenship. From that particular practice alone, we are not sure that the argument that population and citizenship are one and the same. Again, that's why it's important to have the policy to understand the framing of these bills. And then we will move on. The other question is, what is the guiding thought behind reducing the number of years to acquire citizenship? Internationally and in practice, those practitioners would tell us that the gold standard is between 5 to 7 years minimum. In Barbados, it is 7 to 10 years. What is the guiding thought? What is the reason why we would wish to reduce it to 2 years? When we looked around for Commonwealth nations, island nation states, or we could not draw very many similarities. We only found Argentina, their threshold for citizenship is 2 years. But typically, for those in practice, the gold standard is at least 5 to 7 years.
Can I ask you something on this?
Yes, please. Mm-hmm.
I think it's one thing to look around and see what's common practice. I think that certainly is a part of one's consideration for what a jurisdiction should do. But I also think that is important, and I'm assuming that you'll get to that, to hear your own thoughts on what is actually proposed in the legislation. So if we set aside what others have done, what is the harm that you imagine from the period that is proposed in the legislation?
Madam Chair, I think that persons must demonstrate a connection, a deep and abiding connection with a country that they want to become a citizen of. There were comments that were made in the report of the Constitutional Reform Commission, which I think are very relevant because they poll the opinions of not only Barbadians of different backgrounds, races, gender, economic standing in Barbados, but they also went as far afield as the diaspora. And it is something that is held very sacred by Barbadians. When you're dealing with expanding the categories of citizenship, it has to be done in such a way that it doesn't create any social disharmony within society. And that's something that was touched on in that report. So the general thinking is for somebody to show a real and genuine connection with a country, they need to live there. They need to be integrated in society. They need to contribute, and they need to demonstrate this, which is the current focus of the existing legislation. When you're going to submit an application for citizenship, you also have to submit, before it used to be an affidavit, but now it is basically a story that explains how you've integrated into Barbadian society. So you write a statement, you tell them what you do, where you work, where you live, if you are involved in any activities within society. So they know that you really want to have a close connection with the country. And that is not something that you can say can happen if in just 2 or 3 years. You get to know all of the differences that we have, how we behave as Barbadians. Rupi says it well in his song about what it means to be a Bajan. And that takes time. So the thinking was 5 years is enough time, and that's in keeping with, that's if you're married to a Barbadian citizen. The Constitution makes mention of 2 other periods, 7 years if you're a Commonwealth citizen, and 10 years if you're going to be a naturalized citizen. They may be too long now, sorry about that. That may be too long. There may be, there's an argument for truncating that period, but I would respectfully submit that 2 or 3 years is a little bit too short. And persons also have to understand we are different. So understand if you can live here, reside here, thrive here. And that takes time. I'd also, before I finish, our president had made mention to the fact that just because you acquire citizenship does not mean that you automatically are going to move to a country. I am a living case in point. I'm a Barbadian citizen by birth, but I'm a Jamaican citizen by descent because my mother is a Jamaican. And I applied for citizenship because of sentimental reasons. I wanted to have something tangible that showed that I have a connection with that side of my family. I do not live there. I do not work there. I am not tax resident there. I have not invested there. And this is more common than not. So I have to query, really, given my experience as somebody who has operated in this field, this particular sector, for almost 30 years, whether or not we're going to achieve what is envisaged by expanding the categories of citizenship beyond what we have now.
And, sorry.
Yeah, sorry. I think it is a question of what is envisaged, because, and I really, I'm trying not to editorialize too much in this presentation, I am. But I think that arguably, there is, and I think that the regathering principle is kind of a part of the ideology of what is being proposed here by the government, right? Which is that there's an extent to which a long-term efforts to get people to rediscover their connection to the country may not yield short-term benefits, but it has the potential to yield long-term benefits. So I don't want us to consider that the only benefit to what the government is proposing here is to immediately see it in your cash receipts, right? To immediately, in a year or 2 years, to see it in the tax base or in NAS. But arguably, and I am trying to envision the government's argument, arguably, it is also to get people to rekindle and rediscover a connection with the country. And this is in the case, for example, of grandchildren and great-grandchildren. And then in that way, that connection yields an attraction to invest or an attraction to be otherwise connected, because you can make investments and you can add to the public character and the benefit of a country even when you are not there. So again, that's just context. I don't want us to consider this as if we are only talking about immediate economic benefits. In some cases, I think what the government is proposing is, how do we get the world to feel a long-term connection to the country? That is what is borne out, for example, in the work that is being done to secure archives, to get people to come and understand what is their connection to Barbados historically. And the government may respond to say, well, it's not just the short-term economic benefits, it's also a long-term connection. I will stop talking.
And indeed, I thank you very much for that. And that is, I believe that underscores our concern that we did not have a clear guiding policy that we could ensure that we're all at the table understanding context and not having to be, at this point, trying to determine what that context ought to be. And just to answer your question, lady, on the question of what harm, it's not a matter of harm. We believe Barbados has a lot to offer. Attorneys at law, we are and have been in the forefront of developing, within the context of immigration, within the context of citizenship, developing policies and structures that have made this country very attractive. We've done that in the past. We are very committed to that. So when we raise our concerns, what is behind that is a team that says Barbados has a lot to offer. We believe that citizenship, immigration, that level of reform needs to be looked at holistically in the context of what is the new constitution or the Republican Constitution supposed to be. And as you know, we have the entire report, I have it here, the report of the Constitutional Reform Commission here. rights to citizenship flow from the Constitution. So ought we not have that discussion, fully understand how that is to be framed, so that the constitutional rights, whether expanded or otherwise, however we approach it, it is done in a harmonized and systematic way. That's our thinking, that's our training. We want to be able to move from the supreme law of the land, which is the Constitution, allow that to be utilized together with a guiding policy paper. Then in terms of that, then we can frame the constitutional reform and the immigration reform policies. We also would want to harmonize that with the enhanced protocol from CARICOM on the freedom of movement. What does that mean? What does that look like for those of our Caribbean brothers and sisters who want to be a part of that? How do we develop a Barbados where the managed migration is of a nature that we are attracting the very best to build our economy? We are a part of that conversation. We want to be a part of that conversation. But we find that the bills lack the specificity necessary. We find that the immigration and constitutional, the citizenship and immigration bills, they should be sandwiched by the policy, but they should also condescend into the regulations. Because unlike any other piece of legislation, citizenship and immigration lives and breathes in the regulations, unlike any other piece of legislation. So to comment on bills without the advantage of seeing the regulations means that we're not having a complete discussion. And as attorneys at law, that's the first thing our team said. We need to have a complete discussion. We lack context, we lack policy paper, there's an absence of the regulations, and we need to be able to drill down in the context of the other pieces of legislation and in the context of the Constitution in order to apply our minds thoroughly and completely and properly. That's just how we think, that's how we approached this, this presentation today.
This question is really only for my understanding. Are there either jurisdictions currently or circumstances in which you can conceive, where citizenship ought not to be a function of or subsumed under the Constitution? So citizenship ought not to be an issue that flows from the Constitution. Is there a jurisdiction or is there a circumstance in which this is just a question for the benefit of the committee? Please don't infer any intent from what I have asked.
No, we haven't examined that particular point. We could, but I think how it is structured in a Barbadian context works for us. And there is no need to depart from that unless it is not working for us anymore.
Because of our common law and common law heritage, and because of the structure of this nation, this island nation we love so much, the Constitution of Barbados actually framed citizenship.
Right.
As you know, yeah. Jurisdictions such as the UK they don't have a written constitution, but so in Barbados, when the framers in 1966 decided what will be in the supreme law to guide us all these decades later, they determined, look, we are going to determine the categories of citizenship. We're going to frame citizenship within the Constitution. Because the Constitution of Barbados is the supreme law, and we do not approach constitutional reform lightly, which is why the Commission would have taken and been at pains to seek the views of Barbadians and citizens both here and abroad. And they would have taken the time to develop that report. I believe it'd be very, very difficult, and I understand you just said asking for context. It is framed in a way that it is integral. Citizenship is integral to the constitutional rights. So therefore, it would be hard to to not have that intertwined with the Constitution, which is exactly what they intended. They intended that these rights and responsibilities will always stay as part of the bedrock of this nation. So I don't know whether we could easily untangle from that.
I thank you for using the opportunity to let me know how you feel about it. But really, the question was simply whether there are jurisdictions of which we are aware, and I understand that you said you haven't sought an answer to that specific question, that either in their original constitution do not attach the question of citizenship there, or in subsequent reforms remove the question of citizenship. If we don't know, that's fine. But
no, the short answer, UK, for example, they don't have a written constitution, so therefore they would frame their bills differently. Yes.
Right, yeah. Okay, please go ahead.
I would wonder if I could just go, unless there are other questions, and we have it in our comments which we provided. I just want to make a comment on the immigration bill in just a very general way. With the immigration bill, we would have indicated that again, as with the Constitution, as with the citizenship bill, we would want to ensure that regard we have to the Caribbean Community Movement of Skilled Nationals Act and the recent amendments, the qualifying words as it relates to the right of permanent residents to enter into Barbados, and also we, in both the citizenship and in the immigration bills, we wanted to sound a note of caution. We found that the bills did not have provisions in respect of rights of appeal, and therefore it places a lot of power in the minister as opposed, and does not have a second tier for appeal, and we would want to sound a note of caution in respect of that for both citizenship and immigration. These are live issues that I think we would have to make sure that we really apply our minds to. We also have to make sure, and I think we will speak more on that, what is the welcome stamp here? Where does that sit within the framework? Is that something that we would wish to continue to address? When it comes to those who either work and reside or seek to invest in Barbados, we have to be, and I believe Ms. Simmons will speak a little bit more about that, we have to, a very fine line between allowing persons to come and build the nation and not appearing as though we are encouraging any form of citizenship or status by investment, because, as you know, it's still a live issue with the OECD. So we have to be very, very careful how we frame those things. Having worked so hard, and believe me, we feel the pain of it all as attorneys at law, because we felt the fallout when we were on the gray list. And the Barbados Bar Association, we were part of the associations that worked so hard to ensure that the jurisdiction met all of its deadlines as well. So we know that that is something that we'd want to frame very, very carefully. as I said, we have the, I didn't want to drill down into the minutia of the actual sections, but we are willing to take questions on that. Some of it is policy, I know, some of it is the legislative provisions, but at the end of the day, the policy, the thinking, is what guides the legislative provisions. So we would know whether to read the section of the constitutional reform, if I am permitted to read just the section here. I'm
Sorry,
permitted
what?
to do that. This is the report of the Constitutional Reform Commission. Am I permitted to just read a section
Sure.
there? Yes.
I just wanted to caution though that
Sure.
I am not, what is the status of this report? Has it been laid before further revisions? and
Understood. So therefore, I will not make further reference to it. So, but just understand that whatever, we have to still understand that we still have to have a mind to the work of whomever it is, whether it be the Constitutional Reform Commission or whomever is applying their minds to those same rights, the expansion of the categories, the reduction of the years for qualification under immigration, what is the nature of the immigration, what direction we're going in. At the end of the day, we still have to have a careful approach and a harmonized approach to these two bills. So therefore, we urge this honorable committee, in conclusion, we urge this honorable committee to bear the Constitution of Barbados, or what we believe might be what the future Constitution of Barbados will look like with the expanded citizenship categories. Bear in mind the skilled movement and the enhanced protocol of CARICOM. We have to bear in mind what is the policy direction and directive, and whether simple population growth without more is what we're looking for, or whether we're looking for managed migration, which, and there are examples that we can give, that will build and develop this nation. If we have a harmonized approach, I believe we will be able to say, look, we are framing this for the next 40, 50 years to come. Thank you.
I just have a couple additional points to make, which were not touched on in our initial comments that we provided, but it was something when I was preparing for the meeting that came to my mind, and I thought I would make mention of them, and I'm happy to provide the written summary after I leave here for the committee's consideration. Madam President made reference to the fact that there was an absence of regulations. I would just like to expand on that observation. The regulations don't only add flesh to the bones of legislation, but they also are used as a tool to bring in other categories of visas. For example, student visas. So without having sight of that draft, we don't know how student visas will look, if they are going to expand the purview of them. One of the problems that we've encountered, practitioners have encountered, is that you have PhD students, for example, that come to Barbados and enroll at the university and are writing their thesis. They cannot engage in paying work because your student visa does not, or prohibits you from working and getting paid remuneration for your work. So the question, the bar would recommend that the matter of students' visas continue to be addressed in the regulations. There's no reason why it has to be brought into the substantive piece of legislation, but also think of ways that you can expand that and not prohibit persons from being able to work while holding a student visa. We also note that in the draft immigration bill, section 23 makes mention of the fact that regulations under this section may specify the level of fees in respect of different categories of employment and in respect of different categories of persons. Now, the fees that attend a particular type of visa, they are listed in the regulation. They're categorized in accordance with the type of work, for example, in relation to work permits, they're categorized in relation to the type of work that's to be carried out. And they segregate them between CARICOM nationals and non-CARICOM nationals. That hasn't been revisited in well over a decade. So we want to know if there has been an upward revision of the schedule of fees, and if there has been an expansion of the categories of persons listed in the regulations. That we can't answer, and we can't offer any kind of input because we haven't seen the regulations. Also, the forms, the prescribed forms, we have not been furnished with any draft prescribed forms. Because we are pivoting now away from what we have and finding a way to expand and enhance the categories of visas as they exist now, what are the criteria to be met? And what supporting documentation would an applicant have to submit to the Immigration Department in support of their application for any of the categories? We don't know. And this is something that needs to be done in tandem with the passage of the legislation. It can't come after the fact, because you can't say, here we have this wonderful, glossy, shiny new bill, shiny new act, but we're going to use these application forms that do not correlate to what is in the act. So we're hoping that maybe we can pause at this juncture and also bring forward some draft regulations and bill and a draft citizenship bill, which was circulated in tandem with the policy document. So there was an understanding for persons who were asked to comment on those to migrate to Barbados, that get legislative underpinning. We are not seeing any provision for that in this version of the bill, and we would like to know if there's any specific reason why. Currently, that product is framed against 2 cabinet papers that were passed, and it's also used, they inform the criteria which must be met for the minister to exercise his discretion under the current section 13.7.
You mean cabinet decisions, because cabinet papers are not.
Yeah, they were cabinet decisions, yeah. There were two of them. And I guess they want to have flexibility, I'm not sure, and that's why they've done it that way. But given that one of the categories for a special entry permit holder is pinned to an investment in the country of $2 million or more, in 2019, the thinking was that we should give it, that the government should give it legislative underpinning. We're not sure why there is now a departure in 2025 from that thinking. So it's something for the committee to consider.
Let me ask you a question though, because I think that the minister was with us on Friday, and in his presentation, what he suggested is that the legislative framework that the government is seeking is one that is more predictable, more harmonized, and has fewer kind of special categories, exceptions, and so on. And so that the thinking is that anyone who is coming to Barbados should reasonably fit, not under special categories, but under one of these main categories.
Okay.
So you are suggesting that the special entry permit is one that you would like to have retained?
Yes, because it is very popular. It is a popular avenue for persons to migrate to Barbados. And not just those who are looking to invest, but also CARICOM nationals can use it for retirement. So there are various categories that exist.
Right. That something is popular at the time does not mean that as the regime that will replace it is not advised or advisable.
If you're going to replace it with something, and I see there's a possibility that you can use the section that deals with reside or work to craft a product which is akin to the special entry permit. The question is, what do you do with those persons that hold that status now indefinitely? If you're going to do away with it, you're going to have to save those or convert them. But we don't know. We don't know if we are going to say, they're going to say that category is, the thinking is to pivot away from that and go for reside and or work. So those persons who hold indefinite special entry permits will automatically be converted to reside status, indefinite status to.
Or permanent residence.
Yeah, and any of them. But we don't know.
Okay.
We don't know.
Right,
But
so
given the fact that there are several individuals that have invested millions of dollars into this country, we should know.
Agreed, but what I was asking was a specific question, which is, let's assume that they are going to grandfather in all kinds of categories, and we would like to know, right? But the specific question is, I wanted to understand for the purpose of our deliberations later, whether you were making an argument for the retention of a category called special entry permit, because it seems to me that it is not strictly necessary if those people would be covered under the permanent residence qualifications.
I agree with you. But what I'm saying is that I can't advise a person who is coming to the country based on what is being proposed and what exists. There is a difference. So I can't say, they would say, my friend John Brown, he has a special entry permit, can I get one? I can't offer advice. And that's something that we are having serious problems with now, practitioners, because we're asked those questions and we cannot give an informed answer to persons. Right. So I'm not saying that we have to give it legislative underpinning. What I'm saying is that you need to be aware that this category exists, that people hold indefinite special entry permits, that those individuals have invested millions of dollars into Barbados. If you're going to pivot away from that, there should be a method where you convert them to some other form of status, which is what has happened in relation to immigrant status. You're moving away from that to permanent residency, but there is a savings clause. What is going to happen to this category? Yeah. So.
And this exchange underscores what we were saying, that in the absence of seeing the regulations and the sort of specificity that we would like to see in the bill, we can only raise these points, but we're unable to drill down further. And we do actually urge that the regulations for both bills be considered at the same time as the bill itself. It is critical because you're dealing with the status of persons. Thank you.
There is another point we wanted to raise with you, which is the enhancement of the work permit regime. One of the changes that we've noticed in the immigration bill is a departure from Section 70's requirement to ground a work permit application in a Barbadian citizen, permanent resident, or immigrant, or a company. And the language, in my view, without having sight to a policy document, is wide enough to let an individual ground an application for themselves. And that flexibility is useful, for example, when you're dealing with welcome stamp holders. They're coming here, but they're supposed to be working remotely. But there are some that love Barbados. There should be a platform whereby they can convert from the welcome stamp into a work permit, and it should be seamless. So we wanted to get a little bit more substance about the policy behind work permits. We also are of the view that that platform can be used in an enhanced way to migrate businesses of substance and their key personnel to Barbados. But it will entail more discussion. That a product based on that kind of thinking was discussed in 2019, and I'm not sure what happened with those recommendations. But I would raise it, I will expand on it in writing to the committee. I wouldn't want to talk too much about it because Barbados needs to maintain its competitive edge when it comes to immigration products. The next issue I wanted to raise, which I think is also very important, is the need for a dedicated change management team to be established to assist the Barbados Immigration Department in the changes that is going to happen. One of the reasons I think the welcome stamp was so successful is that there were focused attention from individuals when we were crafting the legislation as to what we wanted to achieve. So we clearly understood the policy and how we would go about achieving it and how the legislation would work and how we would launch the product. So I was part of the legislative drafting team, along with Margaret Innes from the Barbados Immigration Department. She was the then Deputy Chief Immigration Officer, but she understood how the department worked, what personnel resources could be utilized to launch the product, and what would be required. We also had Ms. Bridget Lewis, who was a change management expert, who explained to us this is what you need to do in marketing it, when you're looking at the platform for applications, because at that time it was during the pandemic and it was online. We all worked together to get a bill drafted, as well as a training schedule in a 2-week period. And we also trained the immigration staff, so we were able to answer their questions, explain to them, this is what you're going to have to do. If you encounter these issues, you could look to answer them this way. For something as fundamental as the changes which are coming, if this legislation comes to the fore, if both bills come to the fore, this will require a team to help train the immigration department. So that should never be overlooked. I think it's something that is very important.
A little bit beyond the jurisdiction of this committee, but the point is taken.
I had to seize the opportunity because I'm someone who interfaces with the department on a weekly basis. And I'm also acutely aware that they have suffered from a brain drain because several of the older immigration officers have retired. So that knowledge, it has left the department. Do you all have any questions for us?
Any questions from members? So I think you've really sought to summarize your written submission because you didn't touch on quite a few of the points that you submitted.
We were given 15 minutes.
Oh.
we were given a 15-minute time slot.
That's why we're summarizing everything, because we're told.
Oh. Yeah, I think that there are some of the key provisions of the bill that you make reference to. For example, you talk about acquisition of citizenship through grandparents and great-grandparents, and make the point that if the right is truly based on descent, an applicant cannot leapfrog over parents who are not citizens. I wanted you to go into that because it seems to me that if you can't leapfrog, then it is not great-grandparents and grandparents. If you can't leapfrog, it is still children of, because you are depending on the generation just ahead of you to derive citizenship. So what is the suggestion that you're making there?
I think somebody else was dealing with that aspect of it, but I can tell you the mischief that we are trying to avoid Currently, it is only a direct descendant so a child of a Barbadian citizen that can acquire citizenship by descent. The thinking is to expand that to great-grandparents. The difficulty that practitioners will have is that you have to prove from wherever you're claiming it under that that person was a Barbadian. And you have to prove that by submitting to the department original birth certificates. If there's been a name change because of marriage, the original marriage certificate. If the person is divorced and changed their name again. And that is the mischief. To get those original documents all the way up to a great-grandfather is going to prove to be difficult.
But is that mischief? That's,
Practical implications also should be considered. Whereas there are several people that come to us and say, my grandfather was a Bajan, I want him to become a citizen. We understand that. It goes beyond the current category of the Constitution. The government is thinking, yes, let us expand it. But practically speaking, what documentary evidence would you have to submit to the department when you are applying for citizenship by descent as a great-grandchild of a Barbadian?
but I fear that you are considering this legislation in the light of your own capacity to help your clients and not necessarily, what you just raised is not a public mischief matter. Because what you're saying is that it might be difficult to get documentation. It might be difficult. But I'm not seeing how this, when you say public mischief, I'm thinking that there's some advantage that you think people are going to take of the provision.
No, just the mischief. So take the public.
Right.
The mischief which we are trying to.
But how is that mischief? What you've just described
But
is...
maybe I should say it's a difficulty. So maybe the wrong word is the difficulty which we are trying, the practical difficulty which we are encountering regularly and which we are trying to find a way to address that, as well as finding a way to should this law be passed, implement this legislation. How do we submit an application that goes that far back? What documents would be required?
But before you come in, before you come in, I just want to follow this to the because you're asking the government to potentially remove or reconsider a provision because there may be, it may not be straightforward to acquire the documentation. I'm not sure that that is grounds to omit a provision. It may be that as a part of the administration of the legislation, that you now have to open up to examine, well, what are the ways in which, what is the type of documentation you'll accept, what are the ways in which people will have, especially given that there's concurrent work going on in the archives department and in all kinds of other areas. Oh. But I, in fact, of all the things that you said so far, don't accept that this is grounds to remove or reconsider a provision.
May I please add to that as well? Because we view this, that particular provision as expanding the grounds of citizenship, grounds which do not exist currently within the Constitution. So therefore, we are thinking that what was the guiding view, and ought we not have a holistic conversation about the expanded grounds of citizenship, which is something Barbadians want, And we want that conversation, obviously, to reflect what the citizens of Barbados want. If we've expanded the grounds of citizenship that are currently within our Constitution or in the new Republic Constitution, then it makes sense for the Citizenship Bill to expand the additional grounds, in particular, the ones for grandparents and great-grandparents. Further, when we looked at comparative jurisdictions, and that's just how when we practice citizenship and immigration, one of the things that we always do is that we balance jurisdictions to see, we do comparatives, we look for common law and Commonwealth jurisdictions first. And we were at pains to look through, and we found that the jurisdictions which allowed for citizenship through great-grandparents were all European: Bulgaria, Italy, Poland, Hungary, Ireland, Slovenia. And then when we looked further, we found that it was actually quite stringent. Those are jurisdictions that would have, if you look right away, if you're a follower of history, you would know that there was huge mass migration from all of those jurisdictions that would have, you would understand why reaching back to great-grandfather would make a lot of sense. No, I was about to say, that's something that we want. Remember, the managed migration and expansion of the citizenship categories is something that Barbadians have said they want. But we, as attorneys at law, we work from the supreme law, which is the Constitution, and then allow the legislation and the policy document to inform what the bills how the bills will be crafted. So all we're saying is, again, it's applied in a stringent form. If that's what we want, let us have a logical, holistic conversation about the expansion of all the categories of citizenship, including great-grandfather, great-grandmother. Let us look at what Barbadians want for the expansion of the categories. Let's make sure that it is in the Constitution, and then allow the citizenship and immigration bills to reflect and give life to that.
That's a separate point that you've made. The question of whether this flows from the Constitution and whether all citizenship, whether the expansion of citizenship or any consideration of citizenship should first be in the Constitution is a separate point that you've made. The question that I'm asking you about now has to do with this notion in your own comments that, as you just said, several countries in Europe allow citizenship through great-grandparents, but they don't allow you to leapfrog. And I'm saying that if it is truly through great-grandparents and great-grandparents, then all I need to be able to establish, and I don't know how you will establish that without being able to show the complete line anyway, but all that requires me to do is to show that I am the great-grandchild of a Barbadian, and to have the evidence to say that. Now, there's also something that I want us to consider. You said just now, if that is the intent, let us look at it in a holistic way. That's the purpose of this committee. That's the purpose of this committee. This is the place and the time to have the conversation. And what I am cautioning against for the purposes of our discussion is to simply say, the other places that do it in this way, and so we should do it in this way. I think that we have to apply a first principles argument to what we want, yeah? And notwithstanding what you said about not having an overall policy document, I think it is possible to have a first principles conversation about what we want to do. It is interesting to me that you made reference to the mass migration history of places like Poland and Hungary and so on. Because we are seeking here to address something that is material to the lives of Caribbean people. That is to be able to establish, I mean, look at the link between Barbados, other jurisdictions in the Caribbean, and North and South Carolina. There is a thread of ancestry that we are encouraging people to rediscover and make real in their lives. And so to suggest that, well, Europe can do it because they have this history of migration that we don't have.
So you may have misconstrued what I was getting at. Sorry.
I think that the point that what we should be after here is not simply to parrot what other jurisdictions have done in order to be on safe ground. But
No.
what is it that we want to achieve? And we are here at this point now where we have an opportunity to discuss the legislation. So I'm saying, okay, you would ideally want to see a policy document that says citizenship and immigration, and then from that flows a piece of legislation that says citizenship and immigration. That does not always happen, right? So here we are looking at what is the first principles argument for what is before us. And that's what I'm trying to understand from you, because I'm not trying to win an argument. What I'm trying to do is put the committee in the best position to be able to take what you are recommending and to apply it to what we do. So that's why I raised the point about why should you not be able to simply establish a link between a great grandchild and a great grandparent on the one hand, and second, it is likely that you will be able to maintain a thread of the continuity, because it's going to be very difficult to prove that you are a great grandchild of a Barbadian without also proving that you are a grandchild. You follow?
Yes, and let us have that first principles discussion. Why are we speaking about this category and not other expanded categories? Why are we not having this discussion talking about what is it that we wish to expand and why we wish to expand it? We need to have that first principles discussion about the current categories of citizenship, how we wish to expand it to redefine our nation, what are the categories, and it could be great-grandparents, it could also be other categories. And this is, to our mind, a piecemeal approach. We're talking about expansion in the citizenship bill to grandparents and great-grandparents. But there are other categories that Barbadians would wish to look at.
Like
what
what?
are those? What are those? And let us have that discussion. Let us see how we wish to reframe those areas. What is the policy? What are the regulations? How do we access those rights? And it's we've been given a bill to comment on, but the bill is not, to our mind, buttressed by the policy document on one hand and the regulations on the other, so that we can have a full and complete discussion. That's our difficulty. We do not know how it will be applied. We don't know why we want it. We don't know how it will be applied. Very difficult for us to even go any further without having that guidance.
Can I give an example?
Please do.
When you're looking at citizenship by descent, it's commonly pegged to a Barbadian who was born in Barbados. But there seems to be a suggestion that should be removed so that a Barbadian citizen by registration would be able to pass on citizenship as well, or a Barbadian citizen who has been who's acquired it through marriage should be able to pass that on as well. So the question is, by removing the qualification in the instance of citizenship by descent being pegged to a Barbadian who was born here and whose navel string is buried here, and expanding it, are we going to be going too far? Are the floodgates then going to be open? Bearing in mind that whatever happens here, we have to have their social considerations and economic considerations and pressures on our services, public available services such as healthcare, etc. That has to be managed. There's so many interconnected considerations which have to be factored into a policy. And in absence of seeing that policy, we are not sure what is informing the suggested draft, other than what the minister has said publicly. And that has provided some context, but in our view, not enough.
Does the committee have any questions?
As it relates to Section 13 of the bill, where it speaks to speaks to minister's discretion not to be questioned and decisions to be final. I noticed in your comments that you speak of an absence of a right to appeal or review. And if you can speak some more as to, how you would recommend that the approach to this review, whether it be through a tribunal, if it's through judicial, if it's independent, or if it's an administrative type of review, if you can give just give us some recommendations and a greater understanding as to what you meant when you spoke of this absence of a right review and what recommendations you would propose.
We think we must approach the matter with caution in that we would hope that a minister in reaching a decision would take into consideration relevant considerations and would make the right decision. But mistakes do happen sometimes. We're not perfect creatures. So in the case where a mistake has happened, is it not fair and reasonable that somebody should be able to appeal that, to say the minister failed to take into consideration A, B, C, and D in making this determination? And they could appeal to a board. In the existing legislation, there's provision for that, although the board has not met. I don't think it's constituted now. And the difficulty is that the minister should attend those meetings, but it's a very busy individual. So what would be, I think, useful is if the committee considers that they have an appeals board which is set up, which is populated by persons who are knowledgeable in the area of immigration laws, as well as persons who may work in like business persons. So you have a complement of persons whereby you can focus your attention on if there is a matter where the minister didn't get it right, we can try and right that wrong. But there should be a right to appeal. If not, it vests too much power in a minister.
You're saying there should be a committee set up that
And a
can
committee or
reverse.
make sure it's something that can work, that can function properly, that can meet regularly. It's not something that you want to meet once every 6 months or once a year, because that means that that person is waiting to get some relief for an inordinate period of time. It should be a committee or a board that meets regularly, that is properly funded and equipped and populated, that is established to hear appeals from individuals who are aggrieved by a decision of a minister.
And to reverse the decision of a minister,
If it is found that he took into consideration irrelevant considerations and his decision was flawed in a situation like that. But there is a need for it.
I think when minister spoke to it last week, he spoke to in cases of matters of national security, matters where information, because of where he states he may be privy to, that no one at any board or any committee or any tribunal will have access to, and that might have informed any decision that he would have made, that would be made. And in cases like that, he should retain that discretion in terms of making the decision without question. What would be your response?
There can always be exceptions to a general rule. So yes, there may be a need whereby there are issues for national security, where one would want to keep that information confidential, as well as the informants who may have given the government information regarding a particular individual and that type of scenario. But yes, I think you can build in there a carve-out whereby certain appeals would not be suitable to be considered by a tribunal or a committee or a board.
And if I could add that it is a fundamental principle that, and an individual right that someone should have the right to appeal in respect of any decision by any minister. That is a fundamental principle in law. So, as Lynn Ray had indicated, Mr. Simmons had indicated, that does not mean that the right to appeal should not exist. You have the carve-out for certain areas of national security, but the right to appeal should still be retained in the bill, which exists in the current bill, should be retained in the new, in the current act, should be retained in the new bill.
There is an extent to which, though, not every category of application would be subject to appeal. So, for example, a simple immigration decision where an immigration officer or some other officer making a determination may determine that a person does not have a right of entry on this particular occasion. And so there are certain categories of application, certain decisions across the immigration and the citizenship bill that one would argue should not be subject to appeal. Correct? You agree?
We agree. But again, if we had the regulations, we'd be able to drill down and be able to say that we've looked at the regulations, looked at the carve out, look at the manner in which the appeal process has been provided, and we'll be able to comment with specificity. And that is the lack of detail is something that we are very concerned about.
I want to assure you that when this committee first met, we also made the point that it would be beneficial to us to have the regulations. So you're pushing a door that is wide open in this room, right? I wanted to ask about your submission on clause 4 of the immigration bill, which makes reference to EU member states and the UK. And what you say is that Barbados' main business partners are Canada and the US, and they're not included in what's contemplated. I believe that what is proposed here is based on existing economic partnership agreements. So, yes. So what are you proposing here in terms of other jurisdictions that are not mentioned, that they be included?
Yes, there is scope for expansion. Have regard to our major trading partners.
I'm asking if this is a specific recommendation, because it's framed as a question. So are you recommending that we look at expanding beyond the EU and the UK to Canada and the US in terms of the provisions of Section 4?
It may be useful, but we're not sure why that particular clause was framed the way it was.
Mm-hmm.
So knowing that there are major trading partners, but they weren't included, why weren't they included? Why was it limited to only those countries that were listed in? So we don't know. And again, I won't say it. And I'll just say.
Because again, there's economic activity which is concomitant with the bills, and I mean it redounds to the benefit of the nation. But at the end of the day, we just want to understand so that we can fully appreciate the relationship we have with the other countries. Thank you.
If there are no other questions from committee members, I just want to give you one last opportunity to highlight anything that you think you would want to make reference to that you haven't so far had the opportunity, or just to summarize your presentation. Any final minutes?
You'll see the comments that we have made about Section 5 for reside or reside and work. It's in that section that you will look at special entry permit and probably expanding it to have a savings clause. Should it be that you're no longer going forward with that product? I mean, the ability still exists, because there is in section 4, I'll tell you the exact one now. In section 4.6 of the bill, so the minister still retains that power that he has in section 13.7. But the question is, are we going to be pivoting away from that product and then pushing reside and work? And if yes, can we have a savings clause in there that captures those persons who have an indefinite special entry permit?
Yes, so we actually did have a discussion on the reside and work category and consider that that we do not want to the extent that the purpose of the legislation is to make more predictable the immigration and citizenship regime. I would say we, but I think I should say I, because it is my specific feeling on it, would like us to step away from discretionary decision-making, which I believe that reside and work is. If you're going to do away with immigration status for the reason that it is ill-defined and arbitrary, unless reside and work has specific predictable conditions, then we also think that reside and work is really framed just as the minister may make a decision for somebody to be able to reside and work, without any conditions, without any criteria for application. So I think that perhaps the point is taken on being able to codify what happens with the existing special entry permits. But I suspect that the idea is to be able to subsume everything under permanent residency. And to not have special carve-outs for special categories of people. I know that that may be at odds with everything that, certain sectors have depended on, but I think that the extent to which you can make it very clear and predictable the conditions on which, and I compare it to a fiscal incentives framework. In my work as an economic affairs minister, one of the things that we were at pains to do was to be able to give people a certain level of predictability about the conditions under which they would be able to invest in the jurisdiction and not have them be arbitrary decisions of an officer in a room on a given day. So I think that it is a valiant effort and it is a justifiable approach to harmonize the conditions under which a person may live and work in a jurisdiction and not have all of these special kinds of arrangements for special kinds of people. I think that that starts to contribute to a certain kind of inequality that we as a jurisdiction don't want to maintain. But I do take the point that, and as a committee, part of our work will be to be able to give visibility to some existing immigration categories that the proposed legislation does not give visibility to. So the point is taken there. I'm not sure, all I've just said is to say that I'm not sure that under clause 5 is where it would be, because clause 5 we find problematic in itself because it is this reside and work animal that doesn't have any form under the law. And so we'll see how we can give some form.
That category was given as I can just say a placeholder for persons who had married a Barbadian and you wanted to make sure that the marriage was legitimate. So they said, okay, you will get your citizenship approved after 5 years of being married, but in the intervening time, you will have the right to reside and work. So that's how that came about.
Right, but that may have been its origin.
Yes.
But it certainly came to be applied in all kinds of scenarios that people did not understand.
I am aware.
And so I think that to make reference to it in law and still to give it, to have it remain amorphous is not to get to really validate it at all.
definitely agreed, there is a need for us to really define what we want that to look like. And again, to be guided by what the vision is for how that particular section will work and inform the decisions of policymakers going forward. And we entirely agree that the process ought not to appear to be arbitrary. We would not dare say it is arbitrary. No, we wouldn't say that, but we wouldn't want it to appear to be arbitrary or to favor one class of person as opposed to another. I just wanted to just comment on the balance that we have to make that we referred to earlier, when we were speaking in broad terms at the beginning because we were trying to stay within our time limit. But for Section 7, Section 7 speaks to the additional ground for the acquisition of status of a permanent resident and states that by reason of age, Barbadian descent, education, and financial resources. If you look at Section 7 of the immigration bill, it goes on to say that it will be awarded at least 10 points and may be applied to be registered as a permanent resident. We just wanted to sound a note of caution. And again, we don't have everything to hand, but we want to, of course, attract those persons who contribute and who invest. But we just want to sound a note of caution that however we frame it, that we make sure that we stay clear, and we've quoted the November 2018 OECD on resident/citizenship on investment schemes. Now, we have to make sure that however we frame it, that we stay clear of this, because we do know that this is a live issue. And we want to ensure that we, at the end of the day, we give preference to those who will be contributing to the nation. But on the other hand, we have to make sure we're balancing the risk. We want to make sure it does not send us into a risk category. So we have to be careful with how we frame it. We're not necessarily saying, because we are not drafters, so we're not necessarily saying that the way it is drafted will place us there. We just want to make sure that all the checks and balances are put in place in respect of that. Yes? And so therefore, if there are no other questions, we just wish to thank the Joint Select Committee for this opportunity. As I said, it's on behalf of both myself, Ms. Simmons, and the team that worked to pull these together. We really wanted to delve further. We were excited to be able to bring this to the committee. And so therefore, we ask for an opportunity that if the regulations become available, that we are able to be, able to submit further comments. There are so many areas that we wanted to be able to drill down on, and we're very, very, very pleased that we were able to get this far. But we do wish to be afforded an opportunity for further comment should regulations become available anytime soon. But we would caution that we ought not pass a bill without the regulations in place. We caution. Don't give us attorneys more work, please, because what will happen is that clients will come and say, we want to apply, we want access to these provisions. And we'll say, well, the regulations haven't come yet. we will have to wait until the regulations come in order to access these rights.
The point has been made by this committee, so it is taken. Thanks for coming and sharing, the Bar Association's perspectives on the legislation. And I think the hard work of the committee now begins, to be able to consider all the evidence together and make our recommendations to Parliament. So thank you very much.
Obliged. Thank you so much.